All right, Mr. Bishop, the options are: 1, you can proceed with Mr. Booker. 2, you can fire Mr. Booker and you can proceed pro se. If you want to do that, we have to have what's called a Ferretti hearing, and then to advise you on the record of all of the dangers in doing so. The COVID issue has been resolved. The attorneys are fine going forward. The jurors are fine going forward. I'm wearing a mask. It's not an issue. So CDC guidelines are changing. Anyway, so that ship has sailed. We are going forward with this trial. We're in the middle of it.
Okay,
If you want to have a different attorney, you don't get to choose a different attorney in the middle of the trial. We don't stop for you to get a new lawyer. You either proceed with Mr. Booker or you proceed by yourself, period. Two choices. Those are the only ones you have.
Is that on record?
Yes, everything is on the record.
Okay, I would like to fire my attorney if I can find new counsel.
That is not an option. Okay, you're not listening to me, Mr. Bishop. The options are proceed with Mr. Booker or proceed without an attorney. Those are the two options you have at this juncture, period. Nobody in the back can help you. Look at me. I'm talking to you. Two options: proceed with Mr. Booker or proceed pro se and represent yourself, which is a terrible, terrible, terrible idea.
Why is that my only two options?
That's the law, Mr. Bishop, period. That's the law.
So I'm not allowed to seek other counsel?
Not in the middle of trial. No, sir.
Even if I'm not being represented right?
Sir, that's the ruling. Do not argue with me.
Is that on record?
Everything is on record, Mr. Bishop. Everything is on the record. So what do you want to do? You either proceed with Mr. Booker or you proceed without an attorney. But we're not stopping the trial for you to get a new lawyer. That's not how this works.
What about the COVID?
We've already discussed that, sir. You have a mask, I have a mask, we have hand sanitizers, the jurors are fine with it, counsel's fine with it, we are way more than 5 feet away from each other. So you're trying everything you can to not go forward with this trial.
Because I'm not being treated fair.
Okay, you are entitled to your opinion, Mr. Bishop. I'm not going to argue with you. But we are moving forward with the trial, one way or the other. If you're concerned about COVID and you want to stay in the back and do not want to participate in the trial, that is also your right. And we'll try you an extension. That is considered a voluntary absence from court.
Really?
Really?
Because I don't want to be in here and be exposed to COVID?
Then you can sit in the back and we can try the case in your
So
house.
I don't have the right to have any opinion about this?
I don't even understand that question. Those are your choices.
Meaning like make a decision on my behalf.
Okay. Mr. Bishop, this is the last time I'm going to tell you your options, okay? As far as counsel, you either proceed with Mr. Booker or you represent yourself, period. You do not get to stop the trial to hire a new attorney. Number one. Number two, COVID. I've discussed this with counsel. We've mentioned it to the jurors. Everybody is fine with going forward. We have masking in place. We have provided you with a mask. We have hand sanitizer. COVID's been going on for 4 years, folks. We got to figure out how to live with this. We are way more than 5 feet apart, and the CDC guidelines are in the process of changing anyway with respect to the isolation rules. Well, they haven't changed yet. They are in the process of changing them to eliminate the isolation requirements and just to require masks. I am wearing a mask. I will wear a mask throughout the entire trial. So that if you're not comfortable with that, and you want to sit in lockup during the course of the trial, that is your right. And that will be considered a voluntary absence from the proceeding.
Will I be able to hear what's going on?
Nope. There's no feed back there. Nope, you wouldn't be able to hear it. So it's up to you.
So
two choices, sir. Proceed or go in the back. That's it.
And this is on record?
Everything, yes. Everything is on record. Everything I'm saying is on the record. So the appellate courts can hear it. If they think I handled it improperly, they'll have their discretion to do whatever they deem appropriate. So you need to decide now what you're doing. Do you want to stay in the courtroom for the remainder of the proceeding, Mr. Bishop, and participate in this trial?
Participate?
Yes. Testify, not testify, be here when witnesses testify.
Whether I'm here or not, this is going to go forward.
Yes, that is correct. That is correct.
Who will be representing me if I fire my lawyer?
You will represent yourself. Those are your interests.
And if I represent myself and not choose to be in the court, then who will represent?
Nobody. Nobody.
Okay, well, I wanted to fire my attorney and not be in court.
Okay.
Cool.
All right. So that means, if that is the case, you want to fire Mr. Booker and you want to remain in the courtroom. You want to remain in lockup, correct?
Yes.
Okay, so that means there will be no, if you fire Mr. Booker, that means no witnesses are going to testify on your behalf. You will be presenting no evidence, and we will move right into the closing arguments.
So are you saying that I'm not allowed to defend myself?
No, she isn't.
That's not what I'm saying at all. You have a right to defend yourself. You have Mr. Booker here, who again is doing an outstanding job on your behalf.
Not in my
Okay. I told you your options, so decide what you want to do. Do you want to go talk to your client in the back? Okay, let's take 5 minutes.
If he wants to, we'll make a motion.
Go talk to All right, Mr. Booker.
Because we've had a chance to speak in the back, my client out for about the past 5 minutes. He does not desire to be present because he's concerned about COVID. He's okay with going forward with representation, but he does not feel like he has much of a choice in the matter. He's concerned for his physical well-being. He does not want to be in absentia in his own trial. So I think he's going to remain here on the side, but he's indicated it's not by will.
Okay, understood. Okay, then we're going to proceed. Mr. Company, we good? Yes. Okay, all right.
Joining us in Atlanta, Georgia, criminal defense attorney Ecleynne Mercy. Also with us in Phoenix, Arizona, the attorney who represented Jodi Arias. And someday, again, maybe next week, I'm just not going to mention her name. Kirk Nurmi is with us. And in Los Angeles, California, president of the West Coast Trial Lawyers and former federal prosecutor, Nima Rahmani. All right, Ecleynne, you're in Georgia. You're in courtrooms in Georgia. What would Ecleynne do if you're in that situation?
Oh, there's no trial, because the issue is that we were there. Hundreds of thousands of people lost their lives. And when we, the difference is we have COVID protocols to prevent the spread of COVID. And one of the protocols were like negative tests. Before we could even open things, we needed negative tests. So the idea that although preventative measures were done afterwards, he, as a defendant on a trial for his life, has absolutely the right to ask for a postponement, because you don't know his story. We don't know. We don't know how COVID can affect him. We don't know if he has a respiratory issue. We don't know if he visits people in jail. There's so many things that we're not considering, and I think that it should have been for the purposes of judicial economy, because I think that he has a very good appealable issue that court should have stopped.
Kirk Nurmi, he felt safer in jail than inside the courtroom.
Yeah, it's interesting. I think obviously, as the judge pointed out, this man is doing everything he can to delay the trial and or get a new judge on the trial. That's obvious. But I think in his zeal to do that, as Ecleynne kind of touched on, he might have pointed out a really important issue. He might have highlighted something that could get his case overturned, because I cannot think of, and this is going to be an issue, I think, of first impression, right? When is a defendant's health and safety and possible life being put in jeopardy by the judge that's presiding over his case, right? So his choice is possibly put himself in jeopardy and or not attend his trial. And in that regard, I think Ecleynne is spot on. The judge should either delay the trial until she's test negative, what have you, because she's putting all the health of all these people at risk. And I know if I was the defense attorney, I certainly wouldn't want to be there under those circumstances. I don't know that if counsel has voiced that or not, but yeah, in his zeal, he's stumbled across what I think might be a legitimate issue.
Nima Rahmani, this is a defendant who has shocked me twice today. First, the Instagram live from behind bars. Second, he didn't testify.
Well, Vinny, Instagram Live, TikTok Live, I'm a big fan, but not for criminal defendants when you're on trial. And, I would have expected this defendant to testify because he's taken every opportunity to tell his story on social media and elsewhere. Maybe he finally listened to his lawyers and he's gone through many of them. And echoing what Ecleynne and Kirk said, if you're the judge here, and I know the CDC guidelines have changed a little bit from 5 days to 24 hours, but you really want to make sure that these cases are bulletproof on appeal. Sometimes judges just want to move forward, especially when they're frustrated with the pace of a case. They don't want to waste the jurors' time. But, putting this case on hold for, a day or two, even pushing it out to next week, I think would have avoided an unnecessary appellate issue down the road.
Now, for an appellate issue to occur, Ecleynne Mercy, they need to convict him. This is a fascinating case. Like, there's an accusation of the revenge porn, but the most serious is the sexual assault rape here. And I'm wondering, you're talking about members of this following, this Carbon Nation. What will it take for this jury to be convinced that this was a sexual assault versus someone who was in this polyamorous thing and was a little bit upset about the way things went? I don't know. It just seems like it's not your classic sexual assault case or sexual assault accuser.
I honestly don't think it matters. I think he wins it procedurally. The fact that there was a positive COVID test negates all of that. I think that he has the defense rights itself. The fact that he also showed damage and that he didn't testify on his own behalf, because it's either testify and be subject to COVID or, be in the jailhouse and risk testifying via television. So I think that his rights were so infringed that it doesn't matter the facts at this point.